Welcome to SQE1 Preparation Criminal Practice, First Hearing at the Magistrates Court, Summary and Indictable Only Offences by Street Lawyer, helping you to pass first time. The FLK2 Criminal Practice Specification refers to first hearings before the Magistrates Court, classification of offences, and you can see what I've done in red: procedural overview, what will happen at the hearing, and the role of the defence solicitor at the hearing. You'll notice it also refers to plea before venue, procedure on defendants entering plea, advising the client on trial venue, allocation of business between Magistrates Court and Crown Court procedures, sections 19 to 20, section 22 to A, Magistrates Court 1980, and sending without allocation, section 50 and section 51 of the Crime and Disorder Act. I'm really going to be focusing on what is in the red because I'm focusing on offences that relate to summary only and indictable only offences. By the end of this video and other videos that I've produced on what happens at the first hearing for either way offences, I'm hoping you'll have an understanding of the process and law applicable at the first hearing, identify the solicitor's role and the responsibilities at the first hearing at the Magistrates Court, understand the plea process for summary only and indictable only offences, which is what I'm going to be focusing on in this video, and evaluate advice to be given on trial venue and sentencing. Remember, there is a separate video on plea before venue and allocation for either way offences, so please watch that video. By way of SBAQ tips, these may centre on knowing the different processes involved for summary either way and indictable offences. At the first Magistrates Court hearing, this means it's essential you know the offence categorisation, especially for two offences which tends to crop up in single best answer questions: criminal damage, which is less than £5,000, what happens to that at the first hearing, and low value theft, less than £200. And remember that in summary only and indictable offences, the defendant does not have a right to elect a trial or sentence at the Crown Court, and there'll be SBAQ questions on criminal damage and low value theft, so look out for them. So test your knowledge. 1. A solicitor is representing Steve, appearing in the Magistrates Court for a first hearing in relation to an offence of theft of food valued at £25 from a shop. Steve intends to plead not guilty. The solicitor advises Steve that he can only have his trial in the Magistrates Court. Has Steve been given the correct advice about his trial venue? A, yes, because theft is a summary only offence and Steve cannot therefore have his trial in the Crown Court. B, yes, because the facts of this case make it low value shoplifting, which is treated as a summary only offence, and Steve cannot therefore have his trial in the Crown Court. C, yes, because the offence is minor and the magistrates will clearly accept jurisdiction over it, meaning Steve will have his trial in the Magistrates Court. Is the answer D? No, because theft is an either way offence, and so the Magistrates Court may decline jurisdiction and allocate the case to the Crown Court. Or is the answer E? No, because although the facts of this case make it a low value shoplifting, Steve retains his right to elect trial in the Magistrates Court. Test your knowledge. 2. Tony's charged with criminal damage. Tony sprayed graffiti over the paintwork of his employer's expensive Jaguar car, causing damage. The damage to the car will cost £4,500 to repair. Tony has a history of offending in this way when he was much younger. Question is, where will Tony's trial take place? Is it A, B, C, D or E? The trial will take place in the Crown Court because of Tony's history of offending. Is it B, the trial will take place in either the Magistrates Court or the Crown Court, depending on whether or not Tony consents to summary trial or elects trial on indictment? C, the trial will take place in the Magistrate Court as given the value of the damage, this is a summary only offence. Is it D, the trial will take place in either the Magistrates Court or the Crown Court, depending on whether or not magistrates accept jurisdiction to deal with the case? Or is the answer E, the trial will take place in the Crown Court as this is an offence that is only triable on indictment? Test your knowledge. 3. Tony, who is a heroin addict, has been charged with a robbery. It is alleged that Tony stole a purse valued at £5 from his victim by threatening to stab the victim with one of his used needles. The victim suffered no physical injuries. As a result of the robbery, Tony intends to plead not guilty. The question is then, where will Tony's trial take place? Is it A, B, C, D or E? A, the trial will take place in either the Magistrates Court or the Crown Court, depending on whether or not the magistrates accept jurisdiction to deal with the case. Is it B, the trial is likely to take place in the Magistrates Court, as the item stolen is valued at under for £200, and because the victim suffered no physical injury. Is the answer C. The trial may take place in either the Magistrates Court or the Crown Court, depending on whether or not Tony consents to summary trial or elects trial on indictment. Is the answer D. The trial will take place in the Crown Court, as this is an offence that is only trialable on indictment? Or is the answer E. The trial must take place in the Magistrates Court, as the item stolen is valued at under £200, and because the victim suffered no physical injuries. And finally, test your knowledge 4, set of true or false questions. 1. Plea before venue applies to summary only offences. True or false? 2. CPS must provide IDPC in the initial details of the prosecution case. That's shorthand IDPC. At the first hearing, is that true or false? 3. Indictable only offences are tried in the Magistrates Court. Is that true or false? 4. Low value shoplifting under £200 is always a summary offence. Is that true or false? 5. Defendants aged 18 plus appear first in the Magistrates Court. Is that true or false? 6. Allocation hearings decide where all offences are tried. Is that true or false? 7. The CJSSS programme aims to speed up criminal trials. Is that true or false? 8. Summary offences can result in a 12-month sentence in Magistrates Court. Is that true or false? 9. Criminal damage under £5,000 is always indictable. True or false? And 10. Public funding requires passing an interest of justice and means test. Is that true or false? And you can see some of the questions relate to some of the topics that we've covered in other areas, including public funding and legal aid. So we've looked at a couple of test your knowledge questions. Now let's look at some of the questions that can answer these test your knowledge questions. So first question is, what is a plea before venue? It's a procedural step for either way offences to determine the court in which the case will be tried. When it comes to the process, defence indicate their plea, it's guilty or not guilty. If it's guilty indication, the magistrates decide sentencing at the Magistrates Court or commit the sentence to the Crown Court. If it's a not guilty, the allocation procedure is triggered. Note in the red, the above process does not apply to summary and indictable only offences, only either way offences. So then you look at the question of what is an allocation hearing? This is used for either way offences to determine trial venue. And it's used when a person decides to indicate not guilty plea. So the applicability does not apply to summary only offences, and it doesn't apply, allocation hearings don't apply to indictable only offences. A couple of basic questions, which are what determines what happens at the first hearing. The first is legal funding, whether it's going to be public funding, legal aid, or private fees. If no fees are there, there's no public funding, no private fees, then the solicitor will not act. If they do, they'll do it on a pro bono basis, free basis. The second thing that determines what happens at the first hearing is what type of offence is this, classification of offence, how serious the case is. Remember, there's summary only, either way, and indictable only offences. That will determine what happens at the first hearing. The third thing that determines what happens at the first hearing is disclosure by the Crown Prosecution Service to the defence solicitor, and they're meant to provide the initial details of the prosecution case, IDPC. Imagine if the Crown Prosecution don't serve an IDPC, you can expect the case to be adjourned at the first hearing. Point 4 is whether a plea is entered by the defendant. That depends on the type of offence, summary only, either way, and indictable only, and we're going to come on to that. And then we also look at the issue about the power of the court, specifically the jurisdiction of the court, and the jurisdiction specifically of the Magistrates Court, which primarily deals with summary only offences and also some either way offences. But let's look at that in the next couple of slides. Question is, what matters does a solicitor discuss with the client before a plea is entered? Well, solicitor discusses a couple of things. One, discuss public funding eligibility or private fee arrangements, and they complete various forms. That initial details of the prosecution case, they would review the evidence, whatever's been disclosed with the client. They will hopefully be in a position, if they've been given sufficient disclosure by the Crown Prosecution Service, to assess the strengths and weaknesses of the prosecution case. They'll take the client's instructions and comments on the evidence that's been disclosed by the prosecution. They'll take client's instructions and comments. They'll advise on the plea and potential sentencing. They'll consider the client will make a decision on what plea they will enter, or they will indicate, or where this case is heading in terms of if the case goes straight to the Crown Court. Is it going to be a guilty plea or not guilty at the Crown Court? And they will prepare a bail application if required. So now let's look at what happens at the first hearing, and I'm going to split this up into summary offences and indictable offences, and we're going to look at what happens if in a guilty plea scenario and a not guilty plea. So the first slide here is what happens at the first hearing, summary offences, guilty plea. The CPS presents the case facts and criminal record. Defence puts forward mitigation. Magistrates either sentence immediately or adjourn for a pre-sentence report if necessary. The defendant is released on bail or remanded in custody if applicable. And this is the situation when the defendant enters a guilty plea to a summary offence. So the question then is what happens at the first hearing at the Magistrates Court for a summary offence and a not guilty plea is entered by the defendant? Well, this is now a trial situation. Trial issues are identified by the prosecution and defence. What's at stake? What are the issues? Is it an issue of if it's an assault allegation? Is it an issue of, say, for example, self-defence? Is that the issue, or is it an issue that the defendant saying they were not present? If it's an issue of theft, is the issue about whether the person was dishonest or not, whether the person appropriated the property. So the trial issues are identified. The magistrates want to know what are the trial issues. Second point is these case management directions are issued, whereby the prosecution may be required to disclose evidence that they haven't disclosed already in the initial details of the prosecution case. The third issue that's looked at is a trial date is fixed, normally 6 to 8 weeks under the court guidelines, and then bail and bail conditions are reviewed. So they're basically the 4 points that I mentioned are addressed in the first hearing when it comes to a summary offence when a not guilty plea is entered. What you note is the trial does not take place in the Magistrates Court straight away. It's adjourned off for a trial date. Question is what happens if a defendant is charged with a low level value theft or criminal damage? Again, remember, this is some of the offences that crop up in single best answer questions. So with a low value theft, which is under £200, and that's a combination of the things that have alleged to have been stolen, a guilty plea is treated as summary only, and the sentence is at the Magistrates Court. However, not guilty plea is if the not guilty plea is entered by the defendant still has a right to elect Crown Court trial. So you can see what happens about the power of the client, the right to elect. He has no right to elect where his trial takes place if he pleads guilty for a summary only offence, but he does have a right to elect if he pleads not guilty to a theft under £200. And then you look at criminal damage under £5,000. Let's just say the client enters a not guilty plea. That's treated as a summary only matter. The trial therefore will take place at the Magistrates Court. Note therefore the client does not have a right to elect. There is an exception to this, which is where the offence is of criminal damage by fire, either that is arson, or it's criminal damage to a memorial. The client will have a right to elect in those situations. What if the defendant pleads guilty to a criminal damage under £5,000? That is treated as a summary only matter. Therefore, the sentence takes place at the Magistrates Court. Again, note the defendant has no right to elect. The defendant has no right to elect. Now we switch to the first hearing at the Magistrates Court when it comes to indictable offences such as robbery, murder, those type of offences. No pleas entered. That's the general point there. But courts do ask the defendant whether they intend to plead guilty. It's in the Better Case Management form, BCSM form. If they indicate yes. Arrangements are made to allow the defendant to enter a plea ASAP. If the answer is no, arrangements are made for a pre-trial plea hearing, that PTPH, pre-trial plea hearing. The case is sent to the Crown Court under Section 51 of the Crime and Disorder Act 1998, and then the magistrates decide on issues of bail or remanding custody. Now we return to the test your knowledge questions. Feel free to pause the slide and video, read the question in full and check the answer. Again, test your knowledge 2. Feel free to pause the slide and video and read the question and check the answer. Test your knowledge 3. Feel free to pause the slide and video and check the answer. And then finally, test your knowledge 4, which is a series of true or false statements. Feel free to pause the video and slide, read the question, read the statements, and check the answer. Remember, watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge being examined by reading the SRA website for yourself. Revise from a really good SQE book. Attend and participate in class. Prepare your Q&A flashcards. Practice as many SBAQs as possible. I hope the SBAQs that I had in this video are helpful to guide you as to what to look out for. Subscribe to Community Legal Education on YouTube and put in your notifications so you can be the first, you don't miss out on more SQA prep videos. Hope you found this class useful. See you in the next class, and thank you for watching. And I have no idea who that guy is.